really a pleasure to be here. As I mentioned to Dorcas and to several others, it's nice to actually meet some of the faces I've been talking to and dealing with, as well as to meet some of the plaintiffs that I'm representing. It's a very, as you all know, a dedicated group of people who are working for a cause that we all believe in. I believe in as an attorney. I believe in as a father of a former camper. I'm getting a little tired of being introduced as Stephanie's father, but I've gotten used to it over the years. It really was an honor to meet Buzz and to hear him tell again the dedication that he has to this cause, and how important it is to him and to his family to continue the tradition that this outing was given to the Girl Scouts in 1937. And I think he's been a wonderful person to have as a plaintiff. We have a lot of credibility as it is, but to have the great-grandson of the donors certainly even brings more credibility to our position. What I've been asked to do is just kind of summarize where things stand in the litigation. As Dorcas indicated, the Girl Scouts have rejected our attempts, both the friends themselves, and we also sent a letter to them outlining some of our concerns about how things were handled and asking for a meeting to try to reach a reasonable accommodation to allow the island to continue in its intended use, and there was a flat-out rejection of that. That really did lead us to the position where we really had, in our view, no choice but to bring a lawsuit to try to seek a determination from the courts that, in fact, the intent of this gift was that the island would be utilized in perpetuity as a recreation camp for girls and young women. We filed suit in June of 2012 up in Upper New York in Franklin County. We've retained Ron Briggs, who is a very well-respected attorney in Lake Placid. My partner, Steve Rother, from my firm, has a camp up on Lake Placid. He knows Ron personally and of his reputation. We've certainly been very pleased with Ron's work for us up there. The complaint itself, we decided to make it very detailed. It's 47 pages, which is pretty detailed. But it does tell the story, both of the graves and the intention of the gift and why it was important to them. It also does tell some of the story of what occurred when the consolidation of the three councils occurred, and how, from our perspective, and certainly from the Friends' perspective, there was not the transparency that there could have been and should have been. There was not the efforts made to actually preserve the camp and to continue operating it. And had some of those things been done differently, either the camp would still be operating now, or, frankly, the former council could have, before the consolidation, could have imposed restrictions on the deed that would be very clear that it could not be sold the way that the council is now trying to sell it. We've really laid those out in some detail in the complaint. We really have sort of two theories, major theories in the case, and I'll just touch on them really briefly. One is that there's actually a charitable trust, is a legal term, that was created when the Graves gifted the camp, and that is they intended, both from the gift itself and from actually some of the documentation we now have, that the camp would be utilized in perpetuity as a recreation camp for girls and young women. We have a document that states that. We think that's going to be very helpful in our case. The second kind of prong of our case is that even if we weren't to prevail in that theory, that the way the camp had been operated for the 70-plus years, as well as the way the consolidation was handled, ends up creating what's called a constructive trust, and that those actions and inactions, frankly, of the council in 2008 through 2011 create a requirement that a trust be imposed, even if it wasn't specifically imposed in the original documents. That's a more complicated case in a sense, but it's also one part of what we're pursuing. So the complaint itself, the basic relief the complaint is asking for at this point is that the court ultimately determine that there's a restriction on the property, that it cannot be sold and utilized for purposes other than the original intent. We feel we have a good opportunity to make that case, but it's going to have to depend on how the proceedings go forward. Where we stand actually in those proceedings right now is we filed our complaint, and after several changes of attorneys, The Girl Scouts Heart of New Jersey is now being represented by Gordon Reese. That's actually an insurance defense firm, and apparently there's some insurance coverage they have that is financing litigation at this point. We recently served a deposition notice, so we will be deposing Susan Brooks. No, you cannot all attend.
Can I live stream it? Come on.
That deposition notice also included a notice to produce documents, and we included in that list of requested documents a substantial list of documents. Anything that relates to the original 1937 conveyance or even before then, things that occurred after that that had to do with various filings that were made in New York State regarding the status of the property and of the entity that owned it for a while, as well as requests for documents dealing with what occurred prior to and after the consolidation that dealt with Eagle Island in any way, that dealt with the decision-making process that ultimately occurred. So we've asked for those documents to be produced also. Where things stand on that is that we have a tentative agreement that those documents that we requested will be produced in mid-November. Once we have those, we'll review those, and the deposition should be occurring in early December. Date hasn't been specified yet. Once we have that information, it will give us a little better idea of how we'll handle the next step of the litigation. In the normal course, this could proceed for quite some time. I'm not sure if that's in our best interest, if we can figure out a way to try to bring it to a successful conclusion before then. At the same time, because we filed suit in New York State, there's been what's called a lis pendens, which is filed on the property, which basically is a notice that's part of the record now. And in our view, as a practical matter, that means the property will not be sold by the Girl Scout Council in the meantime, because anybody who would purchase it would know it's subject to a pending lawsuit. And if we prevail in the lawsuit, they would acquire it with the same restrictions that we maintain as are on the property now. So, the good news is I don't think the property is going to get sold in the meantime. The unfortunate news is it's sitting there unused. So we're trying to figure out the best strategy to move forward to bring things to a successful head as soon as we can. The other thing I wanted to say very briefly is just to tell a short story, which really goes to why me and my firm wanted to take this case on and be involved in this. As you've heard, my daughter Stephanie was a former camper, and I remember it was probably the second or third year at Eagle Island. She came home from camp, and we decided to take a 2-week vacation in Wellfleet. And one day we were sitting at Gulf Pond watching some sailboats that were being rented on the lake. And Steph, who must have been 10 or 11, maybe that, turned to me and said, "Dad, do you want to go sailing?" And I said, "Yeah, but I don't know how to sail." And she had that Stephanie grin and said, "Well, I do." And what we want to see is that Eagle Island be returned to the uses that lead young women and young men at some point possibly to turn to their father or to their mother or to themselves and say, "I do, I can do this." And because of that, we think this is a cause that is very, very worthwhile us devoting our energies to, and we are looking forward to do so successfully. Thank you.